I'm an attorney. I've been an attorney since 1992. The areas of law I practice and or focus on are criminal defense, personal injury, and bankruptcy. I've been doing bankruptcy since 1992. And unfortunately, it looks like it may become much busier than it has been. This is just kind of a quick overview of where we're going to go today, the roots of bankruptcy, when to think about it, what it is, what can it do for you, and when should you think about it for your own business, or in this situation, when should you think about it for maybe your mentees. Bankruptcy is all federal law. It's in the Constitution, Article 1, Section 8, gave Congress the power to establish the laws of bankruptcy, and they started doing that in 1898. Took them 100 years to get around to it. But the roots of bankruptcy go back to Deuteronomy. In the end of every 7 years, he granted remission of debts. That was because debt was a problem 3,000 years ago. Debt was an issue in the late 1700s when the Constitution was written. So bankruptcy gives an orderly process to dealing with debt, and that's its whole purpose. When to consider bankruptcy. Everybody comes in 2 years too late. They've made decisions that they didn't have to make, or they've spent monies they didn't have to spend. It's difficult to admit the defeat, and actually, as I tell many of my clients, the hardest part is actually saying I need to go see a bankruptcy attorney, because it is it's hard. It's emotionally hard. But what I tell people is be proactive. It may not be for you. It may be the wrong solution for you. But if you know the options, then you know it may be a solution or may not be a solution, and you're better prepared for what might come ahead. Bankruptcy or insolvency. Basically, you owe your creditors more than you can pay them. It's written down in the United States Code, USC. That's where all of the federal laws are written. And inside of that Title 11 are different chapters, 7, 11, and 13. There's actually 9s and 12s. There's lots of different types of bankruptcies. So the nickname for each bankruptcy has just come from where it happened to fall in the statutes. And that's why you'll hear about Chapter 11s. That's like GM, American Airlines. Those are Chapter 13s are reorganizations for people. 11s are reorganizations for big businesses and sometimes people. And Chapter 7s are liquidations for businesses or people, individuals. What happens if you don't do a bankruptcy? Well, you get to the point where you can no longer pay your creditors. They sue you. They can get judgments. Once they have a judgment, they can garnish your wages. They can lien any real property with your name on it, even if somebody else's name is also on it. They can levy bank accounts. They can take money straight out of your bank account. So bankruptcy says we're not going to let creditors do that piecemeal, one at a time. And so you keep getting hit with this one and then that one. Bankruptcy says we're going to do this all at once for everybody. All creditors are going to get treated equally. Any assets in a Chapter 7 that need to be liquidated, we're going to liquidate it, and then we're going to distribute it amongst the different creditor classes, depending on how they are, depending on the class of creditor they're in. So a secured creditors have a lien on some sort of property. They could actually take the property back. They can repossess or foreclose. So secured creditors have that's your car loan or your mortgage, those sorts of things. They're going to get paid first because they get to take their security back. They get to take the house back or the car back. Priority creditors, a special class of creditors you only hear about in bankruptcy. So those are alimony and child support, and some property settlement stuff in divorces. Taxes, most taxes are obviously not going to go away in a bankruptcy, although some do. Driving, hitting and hurting someone while driving while intoxicated will not be discharged in a bankruptcy. You cannot make that go away in a bankruptcy. Unsecured creditors, everybody else. So credit cards, personal loans, Anything without a security interest in it, that's, whoops, those are the last class of creditors to get paid. And so what's a Chapter 7? Well, I'm sorry, I'm still figuring this stuff out. Basically, we call it a fresh start. It's all your assets are sold and the money is distributed to creditors on an equal basis. All creditors in a specific class get treated equally. Once that's finished, the creditors can no longer take any action to collect on that debt. But many times, as I said, the debtors don't have any assets to be sold. There are strict rules about who can qualify. You have to be what's called below the median income for the district that you live in. So in Connecticut, that's about $66,000 for an individual. It's about somewhere around $108,000 for a family of 4. You can qualify if your business debt is greater than your consumer debt. However, your mortgage is considered consumer debt. If you mortgage for your home, is considered consumer debt unless you specifically have taken it out to use in your business. And so that would allow you to qualify. Members of the armed services in certain circumstances. And if you pass what's called a means test, which is a formula, and it says that certain debts are greater than your income, and so you're then allowed to also get into a Chapter 7. So the basic idea of the Chapter 7 is they sell all of your assets, distribute that money to your creditors. But when Congress set all this up, they said, well, if we take everything from everybody, you're going to put people out on the street. Put people on the street, then we have to take care of them, and we don't want to do that. So we're going to allow you to keep certain things through the bankruptcy, and that's what we call exemptions or exempted. These are items that are exempted out of the reach of the creditors, so the creditors can't take these things and sell them and use that money to pay the debts. So what are you allowed to keep? The biggest one, the most important one is you're allowed to keep, under the federal law, $25,000 of equity in your home. That's $50,000 if both you and your spouse are on the home together. Under state law, which you have the option, which you can opt into, is $75,000. And again, doubles if you're filing with your spouse. So that's quite a large piece of equity in your home that you're allowed to keep through a liquidation or a Chapter 7 bankruptcy. $9,000 worth of personal property, that's your pots and pans, your TV, your furniture, that sort of stuff. Tools of the trade, anything you need to be sure you're working. About $25,000 worth of personal injury. An IRA or 401k, $1.3 million you're allowed to keep in your IRA or 401k. And a common mistake I see a lot of people in business making is emptying out their IRAs or 401ks as their business is sinking, and then winding up with a tax hit and not having any money left. Chapter 13 is for individuals. It's a restructuring for an individual over 3 to 5 years. You have to have income in order to be in a 13. You have to have a regular source of income. Many of the same rules as a Chapter 7 apply, but you may be able to retain more property. And some things that don't go away in a Chapter 7 will be discharged in a Chapter 13, like sometimes the penalties, the IRS penalties, those sorts of things there are some specific things that are allowed to that you're allowed to discharge after you've paid into it for 3 or 5 years. The 13 plans allows you to catch up if you're behind on a mortgage or a car payment. This is why most individuals will jump into a 13. They've lost their job, but now they've got another job, but now they're behind on the mortgage or car payment. The bank is telling them, well, you've got to pay it all up at once, otherwise we're coming to repo or foreclose. And the Chapter 13 plan says, nope, you got to take your payments over 3 to 5 years. The bank gets their interest, the bank gets paid in full over that 3 to 5 years, but it allows the individual to catch up. And so that's many times the main reason that people jump into a Chapter 13. It tells the debtor how much they have to pay back to the creditors. So the creditors, the secured creditors will get paid back 100%. Unsecured creditors will get paid back a portion, can be anywhere from 0 to 100% of what they're owed, depending on the circumstances of the individual. Whoops. Sorry, there we go. Chapter 13, so some of the things that are dischargeable in the 13 that aren't dischargeable in the 7. There's the civil fines and civil penalties from the IRS. Debts incurred to pay trust fund taxes. Those are those are your employee withholding or your sales taxes. Those are not dischargeable in the 7, but you can get into a payment plan and pay those back through a Chapter 13. Or willful and malicious injury to property. That's, as you can see, that's property, not person. And so that's a something else that you can get that might be attractive for an individual to jump into a 13 as opposed to a 7. Chapter 11s are corporations and some individuals that have debt limits debts that exceed the Chapter 13 debt limits. You have too much debt, you can't be in a 13, and so you have to go to a Chapter 11. Usually it's a reorganization. It is it's a much more expensive and much more difficult. Many corporations that do these do what are called pre-packaged bankruptcies. They will get all the creditors together for what's called a creditor committee, and everybody will decide who's going to get how much ahead of time, and then present that to the judge. And so that's why you see somebody, somebody like GM going through a bankruptcy and it only takes them 4 months to get in and out, because everything has been set up ahead of time. Businesses or LLCs or incorporations can file for bankruptcy under Chapter 11, but they don't receive a discharge. For most of the stuff that we do as mentors, in small businesses, creditors usually require a personal guarantee. So even though you've shut your business down and the creditors can sue the business or can sue the LLC or the corporation to try and get paid, they almost always require a personal guarantee, so they could also sue that person, the person who's in charge of the business. So that's always a catch that many of my small business people they don't understand when they're signing it as a person. They're not signing it as the business, and they're personally on the hook, which means when they're borrowing money for their business, you want to be careful about their other personal assets, because you may or may not want to put them in jeopardy if the business fails. Oops. Brand new, as in February 19th. This was completely coincidental, but they had added a subchapter 5 to Chapter 11, and the subchapter 5 is for the small business debtors. It's a much easier Chapter 11. It's still a Chapter 11. There was a maximum debt limit of 2.7 million under the CARES Act for 1 year. They bumped that up to 7.5 million, which is really going to probably take care of most of the businesses that we mentor. And again, you have to have greater than 50% business debt to qualify for it. But the owner or the management stays in control and is supervised by the U.S. trustee. You don't have a creditors committee in charge of the business. And there are other costs that are not incurred in the subchapter 5. So you don't have to hire professionals for the creditors committee. So most creditors committees have lawyers and accountants. Don't have to have that. The person in charge of the business gets to continue doing that. So it's much more streamlined, much less expensive. The equity holders retain ownership. So you're not giving up your shares or your ownership interest in the LLC, even if the creditors aren't paid in full. Secured claims can be modified. So if you borrowed money against your house or you've borrowed against a building, you can adjust that. You can extend the maturity rate, lower the interest rate, cram it down. Cram it down is a term of art in bankruptcy. It says I don't have to pay all of what I borrowed against my building if my building is no longer worth what I borrowed. You can strip the lien if it's, you can take the lien completely off of the building in certain circumstances. So they're very, very powerful tools, which I think are going to be highly important here in the next few years as we try to come out of this debacle we're living in right now. What's the effect on the debtor? It is on a consumer credit report for 10 years. You do get credit the day after the discharge. The discharge is the day the bankruptcy ends. In a Chapter 13, you can get credit. You need permission from the bankruptcy court to do that. But if like your car dies while you're in the middle of the Chapter 13, you can get another car. You usually pay a higher interest rate, especially after a Chapter 7, which is about 4 months long. You pay a higher interest rate, you can still get a car loan or that sort of stuff, or credit cards right after the bankruptcy is finished. According to the Fannie Mae, Freddie Mac rules, you're eligible for a mortgage 3 years after the discharge date. Bankruptcy doesn't mean you won't get credit. It's up to the individual creditor. And so they, and many creditors see you as a better credit risk after the bankruptcy. Because you've just cleared all of your unsecured debt. You can't do another Chapter 7 for 8 years. You could do a Chapter 13, but creditors get paid in a 13. So it's really up to the individual creditor. So one of the biggest misconceptions of bankruptcy is I won't get any credit for 10 years. That is just not true. Most people by the end of the 3 years are back to good credit and can qualify for a mortgage under the best rates and the lowest number of points. There's somewhere around 800,000 to 1 million filed every year in the United States. I don't know why we didn't capture the United States. I apologize for that. And everybody kind of knows somebody that's done a bankruptcy. You just don't know they've done it because you don't see a change in their lifestyle because they are keeping their car and continuing to pay on it. They are keeping their house and continuing to pay on it and probably retaining the equity in it. And so everybody knows somebody that has done a bankruptcy. We as mentors, what should we be looking for our mentees? Their expenses outrunning the cash. They're borrowing to continue in business, robbing Peter to pay Paul. And for some businesses, that's kind of okay. Let's say your busy season's the summer and January, February come through and you're strapped for cash in January, February, but April things are going to pick up. But for others, if they don't have that busy season, then that's a key sign. You're not paying your trust fund taxes. If you're not paying your sales tax or your payroll employee withholding taxes as they come due, you can go to jail for that. Just it's time to wrap it up, pay the taxes off, and get out of business. Go do something else, because the government sees that as you stealing from them, that you've collected those taxes for them, and you have the duty, a fiduciary duty, to pay those over to the government. There we go. Again, robbing Peter to pay Paul. Key bills are getting later and later before they get paid. You're not paying the essential bills. And for individuals, it's food, shelter, and clothing. People aren't sleeping at night. That's one of the key signs people come into me with, like, I can't sleep at night. I'm sick all the time. Three top reasons people file for bankruptcy: divorce, loss of job, medical issues. Those are the top 3 reasons. Pre-bankruptcy planning is very important. It really, really is important. I have some bankruptcies I haven't filed for 2 years, waiting for everything to line up. Once we have it lined up, then we file. And it can really save and help the client come out the other side with a much better outcome than if they wait too long. Get some advice. Come see a bankruptcy lawyer. Almost everybody, gives a free initial consultation. I can sit down half an hour with somebody and kind of say, this is what it can do for you. This is what it can't do for you. You're a good candidate. You're a lousy candidate. It doesn't take long for me to figure out whether or not somebody should actually be even thinking about it. Or if they are thinking about it, what steps should they be taking before they begin the process? So all of that, is probably if you take anything away from this presentation, is have your mentees come in earlier rather than later, and then you have the different places where people can get advice to help them through this whole thing.